Yeah, I think that's what I think that's part of what the problem is. I don't know. Yeah, they're going to give us somehow with all our modern technology, we can't make this immediate. I don't know why. This is counting down to 20. Sorry, we're just waiting for technology problems to be solved. Yeah. We're not just trying to make you sweat.
You got to rewind the tape.
That's nice. Yeah. That's nice. Pictures and everything.
Picture's good. Gotta wait for the countdown.
This means in 36 seconds it's going to be ready. Sorry. It's the slowest countdown.
Bad for council.
I think there should have been a buzzer.
Is that? Okay, great. I'll call the case. We're here for oral argument on McMahan versus Grasshopper. It's our number CV-25-0287. Each side has 20 minutes, you know. And you keep whatever time you wish for rebuttal, but you have to keep your time yourself. So please proceed.
Good morning. This is my first time getting before the Supreme Court, so I'm very thankful for the opportunity to do it. After 20 years of practice, this is now the first time. I'm here on behalf of the petitioner, Grasshopper Trans, Inc. My fellow attorney here, Joseph Hubble, who helped me with the briefing, is also here with me as well. I'm Christian Nelson on behalf of...
And just for the record, announce your name for the record as well.
Yes, Christian Nelson on behalf of Grasshopper. We're here because Arizona case law states that we favor cases deciding them on the merits. And that's all Grasshopper is asking this court to do. It's extremely important for you all to understand that we're not trying to move to dismiss based on a defense of insufficient service of process. What we're here about is a void order that was entered before we ever appeared in the case when service had not been properly effectuated. And under clear precedent, that is a void order that must be overturned.
Is there any contest here that the order or that the complaint was not validly served? I mean, anymore. I know it was contested at the trial court.
Yeah, it was contested at the trial court, and the Commissioner Albrecht correctly decided that service had not been properly effectuated, even noted it during the argument. And then on the Court of Appeals, the issue was not challenged as to service, it was only challenged as to waiver. And so the Court of Appeals also did not overturn that issue as well. So it's assumed that service was not properly effectuated under Rule 4.2.
Counsel, let me ask you a question about that. And because in the briefing, it's noted that at least 5 times Grasshopper acknowledged that it had been served. And I understand that Grasshopper's argument is that, well, with the exception of maybe one, which used much more legally precise terminology, that the other 4 times that somehow it was just a colloquial reference to having been served. But is there a rule or is there any case law you can point to that says that there has to be a legal description of service for it to be an judicial admission?
The case law indicates that our statement, and we readily admit, we could have chosen our words more carefully in the briefing, but the case law specifically cites to Reed v. Hinderbrand and Fox Weichbach, both Arizona Supreme Court cases from 1983 and 1953, statements that are not judicial admissions, but actually that we can further explain through additional circumstances to confirm what is actually the true statement. And I want to also reference there, in addition to that case law saying that we can further explain a statement that's made, the Rufino case in 2018, the Court of Appeals said Rufino was served like Lakoski by publication. Okay, the Court of Appeals is using that terminology, and then later in the same opinion said that there was no service there by publication. And so I think that's a real colloquial term. You know, we get served food at a restaurant. We may be handed documents, and that probably would have been the best way of describing the documents being handed to the assistant at the accounting office. But the fact that the Court of Appeals has used that kind of language before, and also that we can further explain based on the case law, it's not a judicial admission of finding, but rather explanation.
I'd like to follow up on that. I'm really troubled by this. I think that this has extended the litigation unnecessarily and caused both the court and your opposing party to incur unnecessary expenses. I used the term twice in your brief, inartful statements. I don't see how this is not a flat-out misrepresentation on which the other side should be able to rely. If I, as a litigator, was not certain I had served properly and called my opposing counsel, and that counsel said, yeah, it was served, I think I and the court ought to be able to rely on that. And I'm not sure why some sort of equitable doctrine like estoppel wouldn't apply here to say, oh, here you are so many months later saying that this person who you described as an assistant to the authorized agent is now a random person. So seeing that type of thing, you know, I may ultimately agree with your legal position, but I find this really, really troublesome. And honestly, if there's any sort of equitable doctrine that could hold you to that, I would be, I would be all in favor of that.
Understood. I want to make sure that it's clear. We never said there was effective service of process or proper service of process or valid service of process. Again, this is where that ambiguity comes in. We weren't trying to make any misrepresentation. I would also come back to the affidavit for default that was filed in this case before we ever made an appearance, before we ever made any statement, that falsely stated that our statutory agent was served. False, right? He was out of town. Plaintiff's counsel knew that based on the process server application, but nevertheless made that false representation to the court. Stated falsely that we didn't timely appear and defend under the rules of civil procedure. False statement, right? Those are statements that he also has to correct under ER 3.3, right? Came to the court. And he hasn't done so. They doubled down on those things, right? Continue to argue that service was effective when it is crystal clear that the statutory agent was not served. And it's crystal clear also that the woman working in his office can't accept service of process because it can't be delegated from the statutory agent.
Given the fact that the question the court's accepted for review is premised on the existence of a void order, I have a sort of, in my mind, a threshold question, and that's which rule applies here? Is it Rule 60B4 as the trial court concluded, or is it Rule 55C? Because I'm struggling with the applicability of Rule 60B4 given the fact that we don't have a final judgment, avoid judgment at issue. And that seems to be the only relief afforded under Rule 60B-4.
You hit the nail on the head. Some other attorneys in my office initially filed a motion to set aside under Rule 55C. And it states for good cause, comma, or a default judgment under Rule 60. And it was unclear to them that that could even be argued because under Rule 60B-4, it talks about judgment, avoid judgment. And so the argument was initially raised for good cause with uncertainty that it could be raised prior to the judgment being entered. When I came into the case, we looked at it, I said, let's just get it out there. Like, we need to talk about it with the court before any further action happens. And so that's why we raised that motion as a Rule 55 motion. Commissioner Albrecht asked us to recast it as a Rule 60 motion because effectively, whether we do it before the default judgment hearing or after, we're making the same argument that we weren't properly served and therefore didn't actually untimely appear.
Was it a 55 motion or was it a motion for reconsider that you filed that then the commissioner said, oh, you need to make this a 60B-4?
It was a Rule 55 motion that was filed on February 19th of 2025, and he asked us at a hearing on March 8th of 2025 to recast it, which we filed it. It was fully briefed. We held a oral argument on that motion, and he said, while I would have liked to see the motion earlier, I think I have no discretion but to set it aside because I find that there is no service.
Well, and counsel, let me ask you, if it's so clear that the initial affidavit for default was false because there was no service, the big question is, why wait so long? Why take so long? And I've got a follow-up for you after that.
Yeah, again, this comes back to the first attorney that was working on this matter. It was unclear. Well, we first filed an answer, and so we were timely in filing that answer because the clock never started. You know, we come back to Rule 4.2. M says 30 days to respond after service has been completed, right? So nothing's untimely. We file an answer, raise different defenses, also have a provision in there incorporating all Rule 12 defenses.
Well, that kind of begs a question, though. I'm sorry for interrupting you, but it begs this question. If there's no proper service, how do you file an answer? Why would you file an answer initially and not try to seek to set aside the default instead?
The correspondence in the record shows that plaintiff's counsel emailed an insurer for the defendant, and that insurer is the one that retained our firm to, as an emergency, like, oh gosh, there's a default entered. And we immediately tried to reach out, cease any further default proceedings, and then we eventually filed an answer 2 weeks later.
You're entitled to, parties in civil can waive personal service and submit themselves to the jurisdiction, correct?
Absolutely.
And that's how it struck me what you did by filing an answer, at least at the time. There's no contest that you've now submitted yourself to the court's jurisdiction post-entry of default, at least, right?
100%. On June 11th, when we filed our answer, we submitted to the personal jurisdiction of court, and we waive any defense under Rule 12b-5. We are only arguing that everything that happened before we appeared, which is that order or clerk assignment to the commissioner for entry of default, that is what has to be set aside because it is void. At that day when the court does that, it has no jurisdiction, has no authority to do so. And under Preston v. Jenkins, Arizona Supreme Court precedent,
And
there is no discretion.
Were there any representations by your client to Mr. McMahan or Mr. McMahon's client or a lawyer about the propriety of the service before the entry of default?
Zero communications, none between. And also, my client also didn't receive the application for entry of default. That was mailed to the statutory agent's office as well, rather than to the address of Grasshopper, which plaintiff's counsel would have because it's right there with the Illinois Secretary of State records showing statutory agent as well as the business address of Grasshopper. So there's a failure to serve the initial complaint and summons. There's also a failure to properly serve the application for entry of default. And that's what there's kind of that, I call it 2 bites or two opportunities to get proper service so you can save and file an answer, and they didn't get that on either occasion. The case law says specifically that the The service rules are interpreted strictly for this because it's a due process issue of wanting to make sure that people get an opportunity, proper notice as to when they should file an appearance as well. I would note that even that the affidavit that was initially filed with the Rule 55 motion mentioned receiving the complaint, not the summons, and forwarding it to the insurance company. That's important because the summons is what talks about when you need to respond by, right? So the person in the safety department that received that at our client forwards it to an insurance company, but they don't necessarily know when they're supposed to respond, didn't notify the owner, and that's why we had a disconnect as getting counsel assigned. And once we've had our firm assigned, we're here. We're not trying to escape the jurisdiction of the court, not trying to get off on a technicality. We want to just defend the case on the merits.
Counsel, let me ask a question about the application of Preston here, making it a hard and fast rule that if the initial default is void, that at some point in time, the defendant can come in and say, hey, wait a minute, there was insufficient service of process. 1 year, 5 years, 10 years, is there a limit to that? Are there conditions or circumstances that a court can take into account, or is your position, it can be 20 years later? I keep moving now, but.
Yeah. Binding Arizona precedent says it can be challenged at any time.
So should we modify it then? Because we're supposed to interpret these rules too to ensure that there's justice in how these cases are handled.
Understood. My argument here is that the Court of Appeals is obligated to file or follow binding precedent. So when that Court of Appeals decision was made, it didn't have the discretion to say, oh, well, you took other actions, you waived your argument about service of process. The case law talks about the trial court not having discretion, right? If it finds that the order is void or the judgment is void, it must set it aside. If we're going to get into weighing discretion, having discretion and talking about factors of was it 1 year, 5 years, 20 years, and then looking at specific conduct, that becomes a heavy fact inquiry about waiver, separately from just simply, was this affected service?
Right.
Because that is the starting point
There's
of
always,
all analysis.
to follow up on that, I mean, to my knowledge, there has always been a line drawn, and that is the court needs jurisdiction. And I'm not aware of any equitable doctrines or waiver or estoppel or anything that gives a court jurisdiction. There's lots of laws saying that the parties cannot stipulate even to a court's jurisdiction. Either you have it or you don't. Are you aware of any authority that says otherwise?
I'm not, Your Honor. And that would be, an example would be under federal court, under diversity jurisdiction. Parties try to say that there's diversity, but the fact remains that there's not. The case must be dismissed. You don't get to use the federal court if there's not a federal question or federal diversity jurisdiction. Same kind of argument here would be, until you effectuate service of process properly by service of the complaint and the summons on person authorized to accept, whether it's a partner, officer, managing or general agent, or someone authorized by appointment of law to accept, nothing starts. No obligation to appear. Just because Grasshopper voluntarily appears later, files a timely answer, it's timely. There is absolutely no default. It can't be effective under Rule 55A.
Well, here procedurally, you challenged before there was a final default judgment, correct?
Correct. And so we're trying to raise this prior to the judgment. And I understand, of course, arguments about delay. They'd like to see it a little earlier. Commissioner Albrecht mentioned the same thing. Commissioner Albrecht said, I don't believe I have any discretion about waiver, and I find no waiver. So also, even if he had discretion, the trial court found no waiver by our actions. And I think that the standard review is you review de novo with regard to service if it's been accomplished, but you defer to the factual findings of the trial court with respect to any factual matters.
As you noted, the trial court urged your client to file for relief under Rule 60B4. If we decide that it's actually Rule 55C that applies here, given the fact that the standard is different, there's good cause expressly incorporated in the text of Rule 55C, what what's our analysis? What is the standard? How do you meet the good cause standard here?
I think that's the issue we had initially on what kind of motion to file here at the court. The good cause is the court on its own has found no service. And therefore it is found it doesn't have authority to act. And therefore it is found it must overturn. And I would, read the quote to you here from Preston v. Jenkins. The jurisdiction of the court to enter any judgment must rest on the affidavit in support of service. Since this affidavit is ineffective to secure jurisdiction, the court necessarily had no power to render judgment against anyone in reliance thereon. The court not only had the power, but the duty to expunge from the record the judgment which is clearly void. The court on its own has to do that when it finds it had no authority.
One of the issues that was raised by the Court of Appeals is the argument that Grasshopper waived any objection to the sufficiency of service because of a failure to file a 12B5, motion to dismiss. Under Arizona law, I think you cited the Sears-Roebuck versus Walker case for the point that a defaulted party cannot file a motion to dismiss under Rule 12. That's a Court of Appeals opinion, but can you elaborate on that, on how that relays? And I understand the points you've been arguing before, but the waiver issue was addressed by the Court of Appeals. So can you address that Sears-Roebuck case?
Yeah, the Sears-Roebuck case, the quote is, the motion to dismiss, however, was not legally cognizable by the trial court while the defendant's appellants were in default, stating basically you couldn't even file a motion to dismiss when there is an entry of default. And so this again leads to somewhat of the confusion of the rules of what ability you have to do when there's an entry of default, but it's invalid, it had no authority. What timing do you do? Do you wait and just not appear at all and wait till there's a judgment and then come in and challenge it? Or do you appear because you want to defend on the merits and raise the issue either in an answer or a motion to dismiss? And we believe that our answer was timely. So, under the analysis the court said that there's no way to file a motion to dismiss. So I'm not sure how we actually could do that. Again, though, I want to stress that we're not trying to move to dismiss. That's the big issue here. We're just saying what you did before we did anything was void and has to be overturned. I'll reserve my 18 seconds.
Thank you. Okay, Mr. Abney.
May it please the court, I'm here today. My name is David Abney. I'm here today on behalf of Brandon McMahan. I usually have an icebreaker. I think the ice has been broken. So it seems to me that what really controls here would probably just be the Montana case that says if you make a general appearance, even if you haven't been properly served, then it's the same as having proper, timely, and valid service of process. And that should take care of the problem.
Well, it would, but under that case, they didn't have an initially arguably void order entered. That was, just as here, they file an answer. Once they file an answer, they've submitted themselves to jurisdiction. But the real question is that case did not answer. It was, what happens if there was no valid service before the court enters an entry of default and didn't yet obtain personal jurisdiction?
I think what happens is you waive any objection to what happened. You can call it a void waiver, we can call it void service, and then with a void order following that. But everybody apparently thought in good faith that there had been service by leaving it with a copy, leaving with Sladana Bojic a copy of the summons complaint because she was identified as a representative of the statutory agent, Lubisa Surejovic, and I'm not going to start any more Slavic names after that. So.
Well, the Chief Justice before, in her always adroit fashion, noted waiver seems to be an alien concept when it comes to jurisdiction. Jurisdiction is not a right. Jurisdiction is a precondition. if there was no jurisdiction because of failure to serve, I don't see how, and a default judgment or a default order was entered based on that, I don't see how a general appearance later on can cure that by virtue of waiver.
Well, you have a problem with the with the sufficiency of service of process. There is specific rules that deal with that. You can come in and file a Rule 12b-5 motion and say, okay, insufficient service of process, you have no jurisdiction, we're gone. But if you fail to do that, the rule itself implies, and necessarily implies, that the reason you're filing that Rule 12b-5 when there has been insufficient service of process, which would give you no jurisdiction, is that there is the time to protest it right there, the Rule 12b-5 motion. And they didn't. In fact, Grasshopper repeatedly filed papers with the court, not only saying that there had been service, but specifically going through the details of it. There had been service on the registered agent of the registered employee of the statutory agent. Did that a couple times with the court, and at least 5 times flat out said there had been service.
That leads to my question, Mr. Abney. Did your client comply with Rule 4.2H in this case? What is your client's position on that, on Rule 4.2H specifically? Was there compliance with that rule?
I'd like to say yes, but I don't think so. You could stretch things a little bit and say, well, there's an agent involved here. When the process goes to the registered agent, the statutory agent, and then the registered agent, the statutory agent immediately gets it over to Grasshopper's agent. But that's stretching it too far. I don't think it was proper service, quite frankly. I have to be honest, unfortunately.
I appreciate the candor. Thank you.
Yes, unfortunately or not.
Mr. Evans, you mentioned that Montana addresses this case, and I agree with the Chief Justice's comments about some of the important factual distinctions between that and that no default had been entered there. So the timing of a general appearance and what was before the court and what the parties were addressing, I think was distinct. What I want to ask you, though, is what I think is more on point is the Lohr case, Lohr v. Citizens Bank of Winslow, where a void judgment had been entered, a default. Then the party appears. Okay, any issues with service of process going forward are waived, but now we have to deal with the circumstance in which you have that default that had been entered before. So my question is, why should we look past Lohr and just hang on Montana, other than it benefits your client?
Well, that's a good reason, but one is later than the other. And to begin with that case from Winslow, I had it on the tip of my tongue. It was fighting what happened on the basis that there had been some sort of proper service, if I recall correctly, and there wasn't any at all. Here, there was an effort at proper service, and everybody thought there was an effort at proper service and litigated the case that way and repeatedly said there had been proper service. I think that fits more with Montana than anything else in Arizona law. They have moved the train along on the assumption, everybody's assumption, that there have been proper service. And then later on, somebody has a bright idea. So, we get to throw it out by putting the word void in, which Justice Lopez, you were talking about void. It's a very confusing issue that was presented to the court. It sort of presumes it's void, and then because it's void, you have no jurisdiction, everything falls in. But this is just a routine matter. You had insufficient service of process. We have specific rules that deal with insufficient service of process and what you do to cure it. You don't just run around and say void, 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 and automatically there's no jurisdiction and the roof falls in. Anytime there's insufficient service of process, there's no jurisdiction, right? I don't mean to pose a question to the court. I think there would be no jurisdiction, but that's okay. The rule deals with that. It says if there is insufficient service of process, which has with it the subtext of no jurisdiction, that's okay. You can fight it with a Rule 12b-5 motion. But if you don't, you waive it. And away we go forward in a nice, orderly process.
Can't you also plead it as an affirmative defense, though, and able to kind of to make sure that then you can hunt down the facts to see, well, was there insufficient service? That's why it's listed as a pleaded affirmative defense.
Yes, you can. In fact, that's where the nuanced part of the opinion came in. I thought that was really cool. I don't see nuance very often, and it is sort of a nuance here because they listed 8 specific affirmative defenses, gave a little detail about each of the specific affirmative defenses. Then they had a paragraph where they threw in every affirmative defense you could imagine, but they said at the beginning, well, by the way, we don't have any facts. And we're putting you on notice that if we ever get facts, we're gonna do this. And so they're saying, we don't have it. We just don't have enough to say insufficient service of process. I don't know if that's bad lawyering, bad grammar, bad luck, bad pleading. I don't know what it is, but that's what they said. And they could have alleged affirmative defense, and that would have preserved the issue. But, in this wishy-washy, weird way that it was done, where you threw everything in the bucket in that last paragraph, that's just not the way to do it.
And assuming that I agree with you, that they didn't follow up timely enough or whatever, they haven't preserved that affirmative defense, especially when they came out they did file a motion, but it was really on excusable neglect and not on insufficiency of service. Can that, I'm not sure I'm grammatically correct, unvoid a void order? Because everything I've seen, at least from Lohr to Gordon to Preston, Springfield, Postal Instant Service, Rufino from the Court of Appeals, all seem to at least lean towards, if you don't have jurisdiction, that order is void and nothing you do after is going to kind of go back, nunc-pro-tunc, to give that court jurisdiction. So that's my dilemma. Do you have any authority that supports that, yes, whatever actions they took post their answer can unring that bell?
Strictly speaking, no. Liberally speaking, yes. Everything is set up under this notion that you have to come forward and say there's been insufficient service of process. And if you don't do that either properly in the answer or in a separate motion later on, you've waived it. So that really kills the voidness part. It's gone. We have a system to already deal with this, and the system worked just fine until the trial court came along and said, no, I don't think so. But given the fact that it was litigated so long and that there was waiver and that everybody understood that there had actually been a service here, there's no reason not to follow the usual rule that if you don't do a 12b5 motion in a timely way and you don't assert an affirmative defense in a realistic way in your answer, then it's waived.
So how do you file a 12b5 motion under these circumstances when our law says you can't?
Our law says you can't.
Well, when under these circumstances that motion couldn't have been filed at this time. So here's where about filing that particular type of motion with the default entered. Or you don't think that applies? I
don't think so. I think once the lawyers who got a hold of this for Grasshopper looked at everything over, they should have been able to figure out, well, maybe we have a defense here, and filed the Rule 12b5 motion. You can file a motion to dismiss before you answer, or put it in the answer. They had a choice of what to do, A, B, or C, and C was what they did. It was nothing.
Well, but I mean, we're a notice pleading state. We've issued a couple of opinions over the last several years that you don't have to have a factually sufficient, necessarily, affirmative defense as long as you're putting the other side on notice. So I don't know, we understand that in civil litigation, you may have your boilerplate paragraph to put the other party on notice, and then over the course of discovery, you develop it. I'm still not seeing where, other than just asserting they could have filed it, so they should have filed it, means that they had to file it if they couldn't.
Okay, I think they had to file it.
I'm going around the same circle you are.
Well, it's a good circle. Let's see if we can step off, though. They had to do something in the nature of putting it into a real affirmative defense. They had to do something like a 12b5 motion. They had to fight it, and they didn't, because I don't think they really sat down and thought to this, what can we do now that we're in a desperate situation? There's a default and everything, the roof's fallen in, we've been litigating for a year. What can we do to rescue this case? What creative thing can we come up with? And they came up with this. Say, we'll call it void. And then we avoid, it's too many voids. We'll call it void, and then we don't get to worrying about Rule 12b5. We don't get to the affirmative defense thing. I think that boilerplate, by the way, and this is apropos, I think that boilerplate language that you see in a lot of these answers is just dead wrong. You can't just go in there and say, all these different defenses, minority, or whatever they are. There's a whole 20 of them at least, maybe more. Just say, I'm going to plead every one of these. I mean, when you don't actually explain to anybody, I don't know what notice state, you guys got to explain a little bit about what is this defense you're talking about. just to put that language in there. And I think a creative, if that's the rule, creative defense lawyers will simply just put it in there always. And this will never come up again because what's in there? It's my boilerplate, a Supreme Court guarantee to get out of jail free card. I can put anything I want in there.
Well, when I use the term misrepresentation before, it encompassed that answer because there were no facts that needed to be ascertained to determine whether service had been effectuated properly or not. They knew, presumably they're held to know whether it was effectuated or not. That still leaves me, though, with the concern about either the court had jurisdiction or it did not have jurisdiction. And if there, you were asked, what case suggests that you can waive jurisdiction and vest the court with jurisdiction, and I didn't hear you come up with one.
Well, I think Montana is one size fits all. I think that's a great case, and cases that follow that's similar sort of reasoning. But I come back to the whole purpose for having this insufficient service of process defense and the ways to deal with it. And there's certain ways to deal with it. It's right there in the rules. It presupposes anytime there's insufficient service of process that there's no jurisdiction, right? I mean, I keep asking questions. I'm sorry. That presupposes that there's no jurisdiction. And yet we have a rule that deals with that. It's just they threw in this void concept and all of a sudden everything seems to tilt like the Titanic going down. And it really shouldn't, because if we just go back to basic principles, the reason we have these rules about insufficient service of process and what to do about it is because it's not a game stopper. It's simply something that comes up. Quite often you don't get service quite right. And what's going to happen about that? Well, I could do an affirmative defense, I could file a motion, or I can just let it go and we'll just go forward with the case. And here, to the extent that there was any thinking going on at Grasshopper, the thinking was very clear, and it was from day one. Their own representatives said, well, okay, we got this. The very same day it was served, and she said on the representative of the statutory agent, we got it. We sent it over to the insurance company that very same day. So they were served that day, indirectly, and maybe not formally as I would have liked to have seen, but they got it.
Well, this reminds me, I'm sympathetic to that, but it reminds me of a case 20 years ago, Falcone versus Maricopa County, in which, as you know, the matter was served on a board of supervisors. They got it, no doubt. They dealt with it, but they didn't do it the right way in terms of filing their notice of service with who was designated for the board of supervisors. And the Court of Appeals, which I was on at the time, said, like you're saying now, well, they got it. The Supreme Court, this court said, not good enough. And that it doesn't matter that everybody thinks they were served and everybody knows about it. If you didn't do it the right way, you don't have service. So going back 20 years to Falcone, how do you get around that?
Oddly enough, I remember Falcone. I think I do. It's in one of those notice of claim disasters, I think. And they didn't get the service exactly right the way the notice of claim statutes say it has to be done.
And it's dismissed.
Yeah, well, when you enter the notice of claim zone, you've entered the twilight zone, which usually is the bad episode of the twilight zone where everything goes wrong. And that's what happened in Falcone. I mean, it was service. They did get it, and yet you didn't go with the minutiae of the notice of claim regulations and statutes, and you were doomed. I don't think that fits here. We're not in a notice of claim land where everything is upside down. Here was a very straightforward process. Everything's all set up in the rules to deal with this kind of situation. If you have insufficient service of process, which presupposes a lack of jurisdiction, you can put it in your affirmative answer, you can file your motion, or you can just say, okay, we're just going to go forward with the case. And without thinking about it, I think, they just decided to go forward with the case. And it was very clear over and over. They said, we were served. Initially, they would say, we were served by a service through the representative of the statutory agent. And then later on, they just took the shorthand, we were served. And earlier on, they were using shorthand also, we were served, over and over. So I think we're actually on pretty solid ground here. It's the void thing. If we could just get rid of that void part of it, we'd be fine. I think throwing the void in there, it just confuses things, and it really doesn't fit a situation where the rules are already set up to deal with insufficient service of process.
Mr. Abney, since we do have a ruling that that the default order was void, I'm going to ask you again about Preston and Montano. And you said a couple of things. You recognized that Preston involved a default and Montano did not, but you emphasized that Montana was the most recent case, decided in 1978 versus 1963 for Preston. What do you have anything else other? Did Montano overrule Preston? I'd like some help reconciling these two cases, ignoring the fact that one involved a default, one didn't. What else do you have in terms of helping us reconcile these two authorities?
It's days like this, I wonder. I don't have anything on the tip of my tongue, Your Honor. I honestly don't. I wish I did.
So is it fair then that the distinguishing point between the two that doesn't require us to call either of them into doubt is the presence of the default in Preston?
I think what solves the problem here, all the way up and down the line, is to simply recognize that we're dealing with an insufficient service of process defense. That's it. And what do you do when that happens? I think I'm repeating myself on it, but it really solves all the problems. Talking about voidness and lack of jurisdiction doesn't help, because under their reasoning, anytime you have an insufficient service of process, there's no jurisdiction. And so, anytime you have insufficient service of process, at any time in the proceedings or 20 years from now, you can come along and say, well, I'm sorry, that was 20 years from your comment.
I said 20, 30.
Okay, 30 years. You could come along and say, okay, you have a lack of jurisdiction, we're out of here, but yet the rules deal with insufficient service of process. This is already taken care of, packaged by the court with a nice bow, and we're done. I hope. Oh, I got a minute. Actually, I'm sorry, like it's all with zeros. I don't have anything further. Any questions?
Don't see any.
Thank you for your time.
Thank you.
Appreciate it.
I'll be very brief. Montana doesn't apply, Florida does. The specific quote says that the appearance, general or specific, will not cure one of jurisdiction to the judgment previously obtained. That's binding Arizona Supreme Court precedent. We have stare decisis. You have to follow that law as well. And the Court of Appeals, more importantly, had to follow it and didn't have the ability to disregard these rules. Falcon, subsequent to that, Melton also addressed the same thing and said, even if you had some actual notice, if it wasn't properly effectuated, it's still not good to start the time.
Thank you. Okay, thank both counsel for your arguments today and your briefing. We'll take the matter under advisement and we'll issue a ruling in due course.